Hello friends, in the series on the income tax cases, today we will discuss the issue of approval under section 151 which is to be taken for the issue of notice under section 148. The issue in the present case is that if the case relates to the assessment year 17-18 and the notice is issued to the assessee under section 148 in July 2022 and this notice was issued because there was some extension by taxation and other laws and there was instruction issued by the Central Board of Direct Taxes after the Ashish Agarwal case. So whether in the present case, if the notice is issued in July 2022 for the assessment year 17-18 due to Ashish Agarwal case, so whether in that case the approval of Principal Commissioner of Income Tax will be required or Principal Chief Commissioner of Income Tax will be required, the issue arose because the period was crossing beyond 3 years. This issue has been taken by Delhi High Court in the case of Twylight Infrastructure Private Limited versus Income Tax Officer and others, and this case has been reported in 463 ITR at page number 702 and the matter has been decided on 5th January 2024. In the present case, there were a number of the writ petitions which has been disposed of by the Delhi High Court. The case relates to the assessment year 17-18 and in some cases the case was also relating to the assessment year 16-17. For example, as in the present case, the assessment year was 17-18. If we add 3 years into this period, the notice should be issued to the assessee up to 31st March 2021 with the approval of the Principal Chief Commissioner of Income Tax as per section 151. If the revenue want to goes beyond 3 years, then he has to take the permission of Principal Chief Commissioner of Income Tax. As all we know that there was dispute between various high courts that those notices which were issued by taking the shelter of taxation and other laws after 31st March 2021 and before 30th June 2021, all those were quashed by the revenue due to the format in which the notices were issued. Later on, in the case of Ashish Agarwal, Supreme Court gave the liberty to the department that they can treat those notices under section 148A clause B. So as per that ruling, in the present case also, the notice under section 148A clause B was issued to the assessee on 26th May 2022 and consequently the notice under section 148 was issued to the assessee on 29th July 2022. The department was relying that since this case relates to the assessment year 17-18, if we had 3 years, that is 31st March 2021. And because of the dispute in the Ashish Agarwal case and because of the Central Board of Direct Taxes circular, the revenue was of the opinion that for this year also, the revenue can take the permission from the PCIT. This mistake has been done by the revenue in a number of cases. But the assessee was saying that since section 151 is not covered by Tola provisions and Tola provisions do not overrule the requirement of section 151, even the Tola provisions do not give the escape route to the department to take the permission from the PCIT in spite of PCCIT. This was the main plea of the assessee. When the Delhi High Court heard the matter, they said that in the present case, the court is relying on the judgment of Ganesh Das Khanna versus Income Tax Officer, which has been reported in 465 ITR at page number 546, in which the case has been decided in favor of the assessee, but in that case, the income escaping assessment was less than 50 lakhs. But in the present batch of writ petitions, the alleged income escaping assessment is 50 lakh or more. The court said that in the present case it is the faint argument of the revenue that the approval under section 151 is not mandatory, and that is the main provision which is in the teeth of the provisions of the act. So the court said that in the present case it is very apparent that the department has crossed the limit of 3 years, so the permission of PCCIT is required in spite of PCIT, and even the Tola provisions and the Ashish Agarwal case does not give right to the department to take the permission from PCIT in spite of PCCIT. At the end of this video, once again I am repeating the name of the case. The name of the case is Twylight Infrastructure Private Limited versus Income Tax Officer and others, and this case has been reported in 463 ITR at page number 702, and the matter has been decided by Honorable Delhi High Court, and the date of the judgment is 5th January 2024.